Well, hello. This is the lecture on Chapter 5, Sources of American Law. We just finished Chapters 1, 2, and 3 exam, and I'll get to grading those soon if I haven't already. And we can discuss anything you want on my Google phone, or you can ask for a one-on-one office call. Okay, Chapter 5, Sources of American Law. You have 3 assignments and an exam just on this chapter. So you need to get started now. I believe everything is due March 8th. I think that's the date, but make sure you check it. It's on all of them, all of the assignments. When we're in the classroom, I always start this class out as brainstorming and asking the class, what is the law? What is the law? And I write everything people say up on the board. So stop and think. What is the law to you? What is the law? Well, the definition of the law is a body of rules of conduct established by and enforced by the government. Laws establish rights, duties, and privileges, and they provide predictability and stability in the law. That's what a law is. It establishes your rights, duties, and privileges. The United States of America based their laws on the English common law. It came over from England, and there you have it, the English common law. Some states settled by Spain and France have civil law, but basically the United States system of government is based on common law. You always read the objective to the book, to the chapter, and after completing the chapter, if you don't know what those chapter objectives say you will know, then go back and read the chapter again, because that's what you need to know in every chapter, in every class, in every book. And if you don't understand after you read it, contact me. That's what I'm here for, virtually. All right, so it starts out on page 120. Primary sources of American law. Primary sources are the law. They are the law, and there's several forms of that. When we'll get to secondary sources, in contrast to primary sources, secondary sources are not the law. So the primary sources of the law in the United States of America are the United States Constitution, which has been in the news a lot with impeachment and what the Constitution speaks about impeachment. So the United States Constitution is the law of the land. And then there are 50 state constitutions. Each state has their own constitution. When I got here, I read part of the Missouri Constitution, and I was fascinated to know that the North Carolina state has a state dog, and it's in the Constitution. And it's the Plot Hound. Never even heard of a Plot Hound. But anyways, it's not the North Carolina State Constitution applies to the state of North Carolina. The United States Constitution applies to all 50 states. So underneath the Constitution, we have to follow that, are statutes. This is another primary source of law. Congress passes federal statutes, and then the 50 state legislatures pass the state statutes. Local governments can pass ordinances. And they're a hierarchy. First is the federal laws, then is the state laws, then is the ordinances, all right? And the hierarchy is if anything under the federal laws conflicts with a federal law, then the federal law wins. Same with the state constitutions. If any constitutional section conflicts with the United States Constitution, the United States Constitution wins. Then we have case law. Case law, judges' opinions, is a form of primary law. And we have common law doctrines. We also have regulations. We have lots of laws. And actually, regulations are created by agencies, and they're not called laws because the Constitution says only Congress and the state governments can make laws. So we manufactured came up with rules. Even though they have the same impact and enforcement as a law, regulations are made by administrative agencies and are not laws. They're called rules and regulations. And actually, my whole dining room would not be large enough for all the rules and regulations just from the IRS. I mean, so we are ruled more by agencies than anything else. All right, all the different agencies, rules and regulations. And in you have a course, LEX 170, Administrative Law. You'll learn all about agency rules and regulations. Again, they cannot be called laws because the Constitution specifies only Congress can pass laws and the state governments. So we made up the name to not violate the Constitution. And then we also have treaties among nations. And be careful how you spell treaties, because when we get to secondary sources, there's a thing called treatises, and they're not treaties. And every time on a test, I have a few students that say treatises are primary sources, and they're not. Treaties, Treaties, treaties. All right, on page 121, is it? Sure. In the margin, it's always good to read the terms in the margin, because as you get into the legal profession, you know that we have our own language. We have words from Latin, and we have just things that don't mean the same in the non-legal world. But in the legal world, we have terms, and you need to learn those terms. All right, let me make sure I went to that. I hope I did. Maybe I did not. Sorry. Okay. Well, the definition of a secondary source of law: one, it's not the law. Only primary sources are the law, and I just named the primary sources. They are research tools to explain the laws and to locate the laws. Right? Secondary sources are encyclopedias. American jurisprudence is one of them, abbreviated AM.JUR, AMJUR. Corpus Juris Secundum, CJS, is another legal encyclopedia, and they are arranged alphabetically by topic, just like the World Book Encyclopedia used to be, which I'm probably the only person that ever bought a set for my children, but they're non-existent now because you can look everything up on the internet. We have those two encyclopedias, AMJUR and Corpus Juris Secundum, in our library on North Campus. If we ever get back there, you can see them, all right, when the world returns to normal. And you can also access them on Westlaw. And if you haven't been accessing Westlaw, just to play with it and have, learn something on how to use it, you need to do that, because that looks great on your resume that you know how to access and use Westlaw. All right. Okay. Next one is treatises. Treatises, spelled differently than treaties. All right. It's a scholarly work by a law professor dealing with a particular topic. Hornbooks are an example. In law school, I had Prosser on tort laws. Prosser wrote all about tort laws, and he would explain what each of the elements of a tort were. All right. So they're very good to have. Articles in law review journals. We also get law review journals in the library at the North Campus. They are secondary sources. They explain a particular topic. Restatements and digests are compilations of law that in each contains topics, the principles of, and then discusses in detail each principle in a particular area of law. Say the law of contracts, it will go into detail discussing what an offer is. It will give examples. It will tell you lead you to cases that define what an offer is in your state and what an acceptance is. So restatements and digest. We also have the North Carolina Digest, which is arranged alphabetically by topic from A to Z. So A might be abandonment, Z would be about zoning, and everything in between. Okay. Very good sources. They're not the law, but they lead you to the law. Right. Okay. Page 121. Case law and the common law tradition. Case law is judge-made law. Those are the judicial opinions handed down by various courts that set precedent. Once a legal decision has been made, then we try to follow that legal decision so people that have the same set of facts and circumstances will know how the court would decide the issue. All right, if we change it every time, it's not going to be any good. So it gives stability and predictability when we follow past decisions. We adhere to something called the doctrine of stare decisis. Doctrine of stare decisis. And stare decisis is spelled S-T-A-R-E. And then decisis is D-E-C-I-S-I-S. Stare decisis. And it's Latin. And it means to stand by things decided. To stand by things decided. Judges and justices are obligated to follow precedent in their own courts or in higher courts in their jurisdiction. All right. So at this point, I write on the board, federal courts, state system, and federal courts. And in the federal court system, SCOTUS, Supreme Court of the United States, is the highest. Then the Court of Appeals for our Fourth Circuit, which North Carolina is, although there are 13 circuits, so there are 13 courts of appeals, but we're in the Fourth Circuit in North Carolina, and it sits in Richmond. And then we have district courts below that. So starts out in a district court, goes to the Court of Appeals, and then up to the Supreme Court of the United States. And my finger's on that. Okay. In the state court system in North Carolina, we have trial courts, we have superior and district courts, and then we go up to the Court of Appeals, and then we go up to the North Carolina Supreme Court that sits in Raleigh. So, any cases that have been decided by the courts of appeals or the Supreme Courts, we have to follow. North Carolina courts must follow North Carolina Supreme Court decisions in the Court of Appeal cases. In the federal court system, North Carolina is in the Fourth Circuit, so we must follow the Supreme Court of the United States, abbreviated SCOTUS. Because POTUS is the President of the United States, and FLOTUS is the First Lady of the United States. And so when you hear FLOTUS and POTUS and SCOTUS, that's what those are. All right. So we must follow the Supreme Court of the United States, courts of appeal cases in the Fourth Circuit. And in Wilmington, we follow the Eastern District trial court decisions. Eastern District, because North Carolina is broken up in the federal system into a Western, Middle, and Eastern District, and we're on the Eastern Coast, so we follow the Eastern District trial courts. Precedent. Binding authority. Binding authority are cases in our jurisdiction. Binding. We have to follow that. Persuasive precedent is outside our jurisdiction. All right, outside our jurisdiction. And they're not binding, they're persuasive. All right, and I hope I talk about that later, but if I don't, let me say this. If there's a case of first impression, I think I do talk about that later. If there's a case of first impression, a case that's never been heard before, never been decided in our jurisdiction, but it has been decided in South Carolina or Virginia, somewhere, we can pull from that in order to see how they decided the case and decide whether or not we want to follow that same ruling that they had in another state, but we don't have to follow its persuasive authority. Okay. Cases of first impression, never been heard here. Let's go somewhere else and see how they determined it and see if we want to follow how they decided. Okay, on page 121 still, we first followed doctrine of stare decisis, right? Let the thing stand. Case been decided, give predictability and stability to our laws. We're just going to go ahead and follow it. But we can always depart from precedent when, one, the ruling was wrong. It was just wrong. Technology changes things. Or three, the social changes in the United States. All right? And then I'm sure you've heard of this, but I always talk about it. In Plessy versus Ferguson in 1896, there was a case where Plessy boarded a train and sat in the white section car. Ferguson, the defendant in the case, was the station manager at the particular railroad train station. This was in Louisiana. In Louisiana, there was a separate Railroad Car Act in the times of racial segregation back in the 1800s. All right. Plessy was arrested and charged with violating the act. He did it on purpose just to see what would happen. All right. SCOTUS ruled the act was constitutional and stated separate but equal is okay. So the separate rail cars for whites, blacks, and anybody of mixed blood, because I think Plessy was black and American Indian. Don't quote me on that. I could be wrong. A little foggy with all this rain in my brain. Okay, so we know that. That's the precedent. Separate but equal is okay. Jump to 1954 in Brown versus Board of Education of Topeka, Kansas, when Topeka, Kansas was fighting desegregation. Right? The school system in Topeka, Kansas didn't want to desegregate. So they had separate schools for blacks and separate schools for whites. And if we followed precedent, stare decisis, then we would say, yeah, they can have separate schools. But we can depart when the precedent was wrong, absolutely wrong. Technology changes or social changes. And so this was wrong, right? Because all men in the Constitution are created equal. Not all women, just all men. All right. So in 1954, they departed from precedent, overruled Plessy versus Ferguson, and said, no, that's wrong. That's wrong. And in the Brown versus Board of Education case, the Supreme Court ruled that separate can never be equal. Right? And so they ordered desegregation of schools nationwide. Okay. Well, here's when I do talk about case of first impression. Okay. So we're on page 122. Cases of first impression. That's a case that's never been heard in your jurisdiction before. It's the first impression of it. All right. So the court can look to another jurisdiction for persuasive authority, but does not need to follow it in the same way. The case mentioned in the text was a 1986 case, In re Baby M. It was a huge case. It got national attention because it was the first case on the validity of surrogacy. Surrogacy is when you artificially implant another woman to carry the child of another couple because the female can or doesn't want to have the baby herself. In the beginning, it was just couldn't. Now I don't know what they do. So, new technology allowed a female egg to be inseminated by a male donor, and then implanted in her uterus. So the court was breaking new ground on new technology. There was no precedent. And in this case, the facts were William and Elizabeth Stern wanted a baby. Miss Stern had MS, and was unable to conceive a child. They tried for years. They placed an ad in the newspaper for a surrogate. Mary Beth Whitehead answered the ad and agreed to carry the baby for the Stearns. They drew up a contract. The Stearns paid all the medical bills. All right. The court ruled it was against public policy to sell a baby and ruled the contract invalid. However, because Mr. Stearn was the biological father, he had donated his sperm, that the Stearns could keep the baby. All right? Because after birth and Mary Beth turned over the child, she had children of her own, and she was married. And there's a movie on this, if you've seen it. It's probably on Netflix or Prime or somewhere out there. There's so much content. Oh my gosh. All right. So anyways, Mary Beth decided after a couple weeks, I want my baby back. All right. So she went and got the baby back, and then it was years of court in between. But the court said that selling a baby is against the law, and it was like selling a baby. But they decided the case on the grounds that the father, who was the sperm donor, and the wife, they were educated people. I believe he was a professor somewhere. And they were good people, and they just wanted the baby. And Mary Beth had other children, and her marriage was falling apart, and her husband left, and things like that. So the couple, she was awarded visitation because she did carry the baby. But if you read the movie, watch the movie. I don't want to blow it for you, but she was interviewed. The child, Imre Baby M, was interviewed a while ago, and she said that she regards the Stearns as her parents. So she grew up mainly with the Stearns. But there had never been a law on that. So that was New Jersey. Okay. Remedies at law versus remedies in equity. What that means is on page 122. Remedies at law. At law, you only get money damages. I want my money. Land or items of value. All right. You're suing for something. You can be awarded at law. You can be awarded money damages, land, or items of value. In equity, they're based on the notion of fair play, fair dealing. So when a remedy at law, when it's not just money you want, when it's inadequate at law, you could file in a court of equity, and that would be allowed specific performance, injunction, rescinding a contract, or reformation of a contract, and that would be remedies in equity. Right? In the beginning, years and years ago, when a plaintiff had to decide whether he wanted to file it in law courts or in equity courts. Now the two have merged, so you don't have to decide where to file, because nowadays you can get, in a case, you can get money damages, you can get specific performance, an injunction, a temporary restraining order, all in the same court system. Okay? But the fun thing about that I liked learning about equity remedies in law school were they're based on fair dealing. And so there are principles and maxims that plaintiff had to adhere to before he could file in a court of equity. On page 124, they have some equitable principles and maxims. And my favorite one was plaintiff must have clean hands. Plaintiff, to come in file in equity, couldn't be the dirty party. He had to be clean hands, they'd say. And whoever seeks equity must do equity. So those were the maxims. So if you were a little dirty in dealing, you couldn't file in the courts of equity. Okay. The doctrine of latches, you've heard about statutes of limitations. That's how long you have to file a case. The time that expires after you can't file a case is the statutes of limitations. And in equity, it's a doctrine of latches, and sometimes it's called repose, similar to statutes of limitations. And doctrine of latches means the plaintiff cannot sit on his rights. He must bring the action within a reasonable time. So they don't adhere to the 3-year statute of limitations for a personal injury. If they use equity, it would be latches, a reasonable time. Okay. Equitable remedies are specific performance. And specific performance means that you want the person that you signed a contract with to specifically perform on that contract. You don't want money. You want that contract. If you find your dream home and you want to purchase that home, and you sign a contract with the seller, and everything comes through fine, you have the cash, you want the house, and the seller pulls out and says, nope, I don't want to sign it. I don't want to sell it. Well, you can file an equity action where you have the court order them to perform specific performance on their contract and force the seller to sell to the buyer. You can have injunctions. If you have someone like my neighbor in the back that drains his pool into your yard or dumps his garbage into your yard over the fence, all right, you want a restraining order, temporary restraining order, or an injunction for him to stop. I don't want money. I want him to stop doing that. Okay. What else is another one? And we talk about. So on page 126, an injunction is a court order in equity directing the defendant to do, or more commonly refrain from doing, a particular act. Oh, their example is burning trash in their yard to prevent. Okay, well, it's his pool water and his lawn droppings. Okay. Okay. Moving on to the bottom of page 126 is terminology of a case. And I have a Word doc posted on Blackboard in this chapter, but Collaborate doesn't allow me to post a Word document, so that's not fun. But it does allow me to post a PDF, and so I'm going to show you, where am I? Yep. I'm going to show you, you have an assignment to do parts of a case and label the parts of a case, answer some questions about parts of a case. You don't label it. When we're in class, we can label it, case parts, but you can't label it and then scan it and send it back to me. So I created 13 questions about it. So this section is essential to read and know. And in this class, we do an exercise together naming all the parts of a case, and then you do one on your own. So it's kind of hard to do it without you guys there. So I posted the questions and I posted the case where I found the answers and what the answers were. So you'll need to look at that. And I also posted terminology of case law that I won't go over, but you do need to read all of that. I will say that in North Carolina, we have an official reporter and an unofficial reporter. And the reporter for the North Carolina Supreme Courts, and this is on this paper, is the North Carolina Reports. And for the official reporter for the Court of Appeals, it's the North Carolina Court of Appeals Reports. We have an unofficial reporter put out, not by the state. State puts out the official ones. Westlaw puts out the other ones, is the Southeastern Reporter. Okay, same cases, but they're in two different sets of reporters. But you do need to know the official reporter for North Carolina and the other unofficials. So let me go to share the file, which I never have good luck with, but I'm learning. This is parts of a case, start case, which is the example we do in class. Okay. Okay, let me make this bigger. Okay. All right. So this is a case printed out on Westlaw, and so you will see up at the top, style of the case. The style of the case is the case name, and I asked that as the first question in State versus Ratashara. What is the style of the case? So the case name is State versus Ratashara. When you want the entire citation, it's the case name, and then it's comma 177 North Carolina app. And notice at Westlaw they don't put a space between C period and app, but there is a space between that according to the Blue Book, and North Carolina follows the Blue Book. So you would have N period C period space APP, and then the page number that the case starts on, and then the year it was decided. 177 is the volume that the case is in the North Carolina official appellate court reports. All right. Okay. And this is posted on Blackboard. I probably should have, I might put a note before you view this lecture to print that out and have it with you so you can follow along. All right. So the names of the reporters: North Carolina Courts of Appeals reports and the Southeastern Reporter. And they're in two different volumes. And this is underneath is the Southeastern Reporter. That's the unofficial reporter. It's in volume 628, Southeast 2nd, 471, and of course the same year because it's the same case. Okay. So that would answer question number 2. What are the two names of the reporters? And then what volume are they in? Volume 177 for the official, volume 628 for the unofficial. All right. In this, you see that it's Stark versus Ratashara. All right. They always have the given names of the people, but in citations you don't write out the names. The given names. What you write out is what you see in capital letters. It's only surnames, with some exceptions, but we're going to go with the general rule. It's only surnames, just like it is up here, Stark versus Ratashara. All right, and this is not from a trial court because we don't record those because we'd have too many. We don't publish those because we'd have too many cases. This is from the Court of Appeals. We publish in North Carolina Court of Appeals and Supreme Court of North Carolina. So you know it's going to be the Court of Appeals ruling on whether or not the trial court decided the case correctly. Okay, underneath right here is the docket number. COA stands for Court of Appeals in 2005, and it was the 1,119th case heard that year. It was decided in May of 2006. Even though it was heard in 2005, they take time deciding it. Now the next things, this is not the case. This is not the case. Nothing is the case until I show you where it is later. This is what the publishers have done to the case. They give a synopsis, and it's a research tool, all right, but it's not part of the case. So you can never quote on a legal document anything that comes before you see the word opinion in the opinion. All right. So this is a background, this procedural history, what the trial court held. So it's good to know it's a research tool, but it's not part of the law. It's not precedent. Okay. And this is what the Court of, went through it. Court of Appeals held, order vacated. So then you get into it. We have these wonderful things called head notes. Head notes. And it's the Westlaw forms of research, West head notes. And what they mean is they have a keynote system. See that little key? And under the topic divorce, everything you want to know about divorce has its own little separate key number. All right. So it's a good tool, and we have West Digest on North Carolina law in the library, and you can also access it on Westlaw. But if you wanted to find a case that said when a party has secured an absolute divorce, it is beyond the power of the court thereafter to enter order awarding alimony, that would be under this keynote. All right, and you find that in the Westlaw keynote system, and it will give you every case that's precedent on that issue. All right, so head notes are huge. Merger and bar of cases, it's probably not that important in this one, in divorce. All right, so those are head notes, not the case. All right, now remember up here, the case started on page 449. All right, when you print them out though, it prints out as page 1. But it's not page 1, it's page 449. So if you were citing to a judge in a memorandum or some other document they need to know, you wouldn't put it's cited on page 1 because it's page 449. And the next page would then be page 450, even though it'll say page 2. Okay? All right. So there's the case again. It's a short case. And more head notes. Topic is courts. Topic is divorce. And then it says opinion. Case begins here. Now you're safe to quote anything from the opinion. All right. Here, which I think is hilarious, the wife had an attorney in the Court of Appeals, and the Stark represented himself. So it says, attorneys and law firms, Christopher Paul Stark, pro se. All right, so the wife, I believe, won below. I'm not going to say that, but I'm pretty sure they did. Yes. All right, and he appealed. All right, on his own, and he beat out Michael R. Bruce Danbury, the attorney for the wife. All right. So here it says Judge Jackson, he authored the opinion. He wrote the opinion. Then you read the opinion. All right. And the questions are, what did the trial court hold? What page is head note 1 discussed on? All right. And head note 1, let me show you how they're designated. Now I can't find it. Let's see. Here we go. All right. This is how you can see where it's designated. This little thing here designates head note number 1, a 1 in brackets. All right, so then you will know that head note number 1 is discussed on page 451 because it's not discussed on the first page, second page, and this says the third page. It's not. All right, those are the head notes. So when you're searching for a case, you first read the head notes for your issue, because cases have several issues. But if that's the direct issue you want to pull out, then you can jump into the opinion where that head note is discussed. Okay? Okay. Parts of the case. So if I asked, did the Court of Appeals uphold the trial court's decision when they vacated? No, they did not. It could say reversed. It can say overruled, vacated. They vacated the judgment granting alimony. And these numbers are just the ones to the questions. And I gave you the questions on Blackboard, the list of the questions and the answers. So you can use this as a guide and do this one first before you do the Cathay versus Cathay case. All right. And then if I ask who wrote the opinion, we already did that. But then what type of opinion is this? Judge Elmore and Steelman concur. So we know in courts of appeals cases in North Carolina, they sit in panels of 3. So all 3 agreed. So it's a unanimous decision. Okay? Okay. How do I get rid of that? Like, this is one I always have problem with. And I remember it, but then I don't remember. I want to get rid of this. Okay. I want to stop sharing. I don't want a next slide. Oh, I just did it last night. Navigate slides. One time I turned off the recorder. That wasn't it. Technologically advanced, I'm not. Okay, let's try again. Here, maybe I can. Here, stop sharing. Stop sharing. There we go. I know the laws. I don't know how to do this collaborate, but I'm going to learn because apparently we're doing it for a while. All right. So in this one, the case title is the style of the case. Surnames only, no first names. And then they're plaintiff and defendant in the trial court system. And then when they get to the Court of Appeals, they're no longer plaintiff and defendant. They're appellant and appellee. The appellant is the party asking for a review, and the appellee is the person that didn't want to file. They wanted it to remain the same. So let me see where we are now. Okay. The terminology goes on page 126, 127, and now we're on page 128. Justices and justices and judges. SCOTUS or justices. All right, everybody else is a judge. So the types of opinions rendered in a court case are unanimous, all agree. Majority, not all agree, but the side with the most agreeing rules. A plurality opinion, the largest number of judges agree, but less than a majority. And a plurality opinion is not precedent, it's not binding. Unanimous opinions are, and majority opinions are. Concurring opinions can be in a unanimous or a majority, and the concurring opinion is just something a judge says. You guys came up with the right answer. I agree with the court opinion, but I concur for a different reason. I just want to write my 2 cents and tell you guys you missed the point. I agree with you, but this is why you should have been the reason. And the dissenting opinion is never the precedent, because the justices or judges do not agree with the majority, and they write a dissenting opinion. You guys got it wrong. This is what it should have been. So we have an adversarial system of justice right? The goal is to win. He who has the best lawyer wins. On page 129, they go into the Constitution. You probably should already know should probably already know all the amendments, right? Should. First Amendment rights, Second Amendment rights. We hear a lot about our rights. Statutory law. Statutory law. Statutes, federal statutes are enacted by Congress. State statutes are enacted by state legislatures. And it goes in to tell you that if a conflict between a federal and state statute exists, then federal preempts. It's a preemption doctrine. Federal law, until proved unconstitutional, preempts a state statute that conflicts, right? And then we have the ordinances, which are the lowest level. A bit about uniform laws on page 134. Laws vary from state to state because we have the right to do that. Unless it's a federal law, then we all follow that. We can make our own contract rules, our own marriage rules, our own probate rules, because that's up to the states to do that. So they do have uniform laws, all right? They had a conference on uniform laws to decide that laws kind of should be kind of the same throughout the different states, but they never are. Well, no, they are sometimes, like murder's illegal in every state. But not everybody has to have the death penalty, right? So the laws aren't all the same, and they tried to make them so when you travel from one state to another, so some laws are similar to other laws, but you're allowed to have your own laws in your state. Some laws, like the Uniform Commercial Code, are basically the same state from state because that's for commercialism throughout the United States, so it's better to have those the same. And they allow you to pick and choose from the UCC code what you want. I don't remember the statute for North Carolina UCC code, but we do have our UCC code, and it basically follows the UCC. Oh, I didn't know we had agency in here. Did I skip a page? Sure. All right, administrative law. I did talk about that a little bit, and we get into it more in 170, but remember on page 136 here, LEX 170, you'll get into it in real depth. I think I teach that in the summers. I think so. Administrative law are created by statutes. It has to be an act introduced either in the federal level or the state level. If it's a federal agency, if it's a federal law, then it's a federal agency. If it's a state law, it's a state agency. And it has to be created by the legislature or Congress. And then it gives the rights and duties and what areas that the agency has oversees. The FDAC, the alcohol, tobacco, and firearms, which I always thought it was kind of weird they put alcohol, tobacco, and firearms in one agency. The TSA, Transportation Security Act. All right, so big deal. They make rules and regulations that rule our lives every day. Like you have to get a driver's license. Why? Why do I have to have a driver's license? Because they say so. On page 138, national law. National law relates to a particular nation. So our federal laws in the United States are national laws. Right? International law is laws that govern relations between nations. So United States and Great Britain, United States, Canada, or Mexico, those are international laws. And then treaties are agreements between two or more nations. Okay. That's why I didn't go over it. I say review pages 129 to 138 on your own and let me know if you have a question. But you can always let me know if you have a question. All right, so that's basically sources of American law. You will use this knowledge in every class that you take here at Cape Fear Community College and probably in your life. So the assignment, there's some questions from the chapter. There's a few, I think I have you do 4 case citations just to really get the feel for it. You're going to learn more about that in LEX 120 and 121 on how to cite cases. Great. So you have the Cathay versus Cathay case to read the case and pull out the parts that I ask questions about. I think there's 10 or 13 questions. And then you have an exam on this chapter. So that's the 3 assignments. Textbook questions, few cases to cite correctly, and then the parts of the case. So, okay, I hope you all enjoy this lecture. I try so hard, and I just want to be back in the classroom. I want to write on the board. I want to turn around and interact with you guys. So hopefully soon. Get vaccinated when you can. Wear a mask if you believe in vaccinations. Whatever, I'm not telling you what to do. But I want some sense of normalcy soon, as I know all of you do. Okay. Have a good rest of your day, and contact me if you have questions. I'm going to stop recording.